Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Good afternoon. Okay, so a few of us are going over some of the recent cases, and we love to take advantage of a colleague who puts out a great summary of some of the cases that have come out, and they help kind of narrow down or drill down on certain legal concepts that anyone practicing in this area has to know and has to kind of massage their clients into embracing and realizing that they have to, particularly when it comes to evidence, have to focus on to try to build that strongest case they can have so they can have the best chance of prevailing and prevailing earlier rather than later. So the one we just finished up, so I wanted to share it before I head back into a different workshop on a different case that we're working on this morning. This is on a recent case, came out in October, Toledo versus Commissioner. And of course, if right now it's Commissioner O'Malley, but that's really kind of irrelevant because it would be whatever commissioner's in place at the time. And the case obviously started long before. Okay, this happened to be in the 10th Circuit. And as I've mentioned before, everyone is located within a circuit. So if you ever appeal your case up to federal district court and up to circuit court, you will be in a particular circuit. 10th case is, 10th Circuit is not the one I sit in, but I have cases at the administrative level, probably in all circuits in the country. And if that person was going to go to, appeal to FDC, if something went awry in the case, which I certainly hope that wouldn't happen, then they would be heard at that, that particular circuit. You can't really jump around. So this is from October, and this also sounds like a good one. And it's summed up nicely by Adriana, who does a great job. And I'm going to get the link to her LinkedIn page. I'm actually looking at it on one of our disability private group pages, but I'll get you the one that I believe you could see because it's her own page, not in a private group. Same exact summary she puts up there, and she attaches the case so you can look at the case as well. This one, she says, it reminds us of just how crucial medical evidence is in disability claims and how courts view appeals when an ALJ's decision is challenged. All right, so it's about the medical evidence. The one that we recently discussed was about substantial evidence and how puny that is, and that's all an ALJ has to have been found to have met, and how inconsistencies in ADLs and such, along with medical records, when things show up inconsistently, what you're doing versus what you're saying, and how that can really put a thumb or put a hammer on the nail of the case. Okay, so this is, again, Toledo versus Commissioner. So Toledo suffered from some chronic conditions, including rheumatoid arthritis, fibromyalgia, anxiety, depression, and applied for disability benefits, of course. She had argued that her conditions severely limited her ability to work. However, and it looks like she had multiple appeals and hearings and remand. After 2 rounds with the ALJ and multiple reviews, her claim was denied. And in this case, the 10th Circuit upheld the decision of denial. So let's get into what the major points are that we want to take away. And again, it's about medical evidence. So stay tuned, because if you're a claimant versus if you are a representative, just tuning in here, as a claimant, you are the one that controls. You are the only person on this side of the fence of your case that controls your medical treatment. And I say the only one on this side of the case that has the control, meaning I know there are other factors in your life that make you not feel you have control of your medical treatment choices. And we all know that's true. We all understand the cost that inhibits many of us from getting all of the treatment we might otherwise need or want. But when I say you're the one in control, it's because you're the only one that can pursue it. Not saying you're always going to get what you want when you do, but we can't pursue it for you. So this is really important for claimants to pay attention to. All right. And again, 10th Circuit, but these principles tend to be true in all circuits. It's just that this circuit does not control lower cases in a different circuit. But because it's all relying on the same rules of Social Security, these interpretations all tend to be very, very in line with one another. So what you learn here is certainly not going to hurt your case if you take heed in a different circuit, generally speaking. Okay, so Adriana tells us that the ALJ didn't completely reject claimant Toledo's claims, but found that the medical evidence didn't fully support her allegations, especially regarding hand limitations. Now, it's funny, they used to use a term called credibility, not finding a claimant's allegations to be credible. And they changed the terminology because, political correctness, it made it sound like you're saying they're lying, they're not credible. So they changed it to, and you might see this if you get a denial with an ALJ, to not wholly consistent with the rest of the evidence. So what you say is not wholly consistent with the rest of the evidence. Okay, so then again, she had mentioned that it's specifically about hand limitations. Although she had reported severe pain, the court pointed out, so the court found it important, that her range of motion and ability to manipulate objects like paper clips was indicated in the record to be normal. This is deadly, guys. I mean, and it's so not unusual. I don't know if it's because they're using canned medical record software where everything is going to come out to be normal unless that medical assistant or doctor presses the button to show that you complained about it. It's or if they don't test your range of motion and they just say it's normal, it's terrible. So, but this is where it's going to come bite you. This decision shows, she says, how critical it is for subjective reports of pain to be backed by solid, consistent medical documentation. Kudos. It's like the gospel, guys. You have to do this, or else they're going to be picking out. They're going to be going through with a fine-tooth comb. The ALJ's judgment on credibility is another area she goes into. And one point that stood out to her was how the court backed the ALJ's decision not to fully credit the claimant Toledo's complaints about pain. So how did the court back up the ALJ's decision? The ALJ didn't need to dissect every piece of evidence. And this is true, and this is painfully true sometimes. It was enough, the court found, that they considered the relevant parts and explained their reasoning. It is a good reminder, and this is Adriana's share here, and I can't agree more. It's a good reminder that courts give a lot of deference to ALJs when they provide specific reasons for their decisions. So it's a good reminder that the courts give a lot of deference to ALJs, and we've said this time and time again. They have a lot of discretion that's not going to be disturbed just because someone might have found something slightly more persuasive than something the ALJ found. As long as but they do have to give specific reasons for their decisions. What constitutes a specific reason for the decision can sometimes be up to dispute, and sometimes they give a reason that is not specific enough, and sometimes it can be an appealable issue because they didn't. So that's something to look at too. They held against you on a specific fact they found, but they didn't explain really why. That's something to look for in a denial decision when you're going to take it up the pike to appeals counsel even. Okay, another point they made had to do with residual functional capacity. That's at RFC. The RFC is what the SSA and the sequential evaluation process determines at step 3. If you don't meet a listing, they find out what your RFC is. They give an assessment of what that'll be based on your medical records. So even with her impairments, apparently, the ALJ found that Toledo could still handle sedentary work with limitations. The court agreed, highlighting that as long as there is some substantial evidence supporting the ALJ's, there's that substantial evidence word again, right? Supporting the ALJ's RFC determination, courts will likely uphold it. This is a reminder to really focus on how we present medical findings when challenging these decisions. Clear evidence that contradicts the ALJ's conclusion is essential. So I would say again, always, if you're pro se in particular, you need to know your evidence. You need to periodically be getting your progress notes from the doctors, your test results, and you have to always make sure that you're getting updated diagnostics. Particularly the MRI that you haven't had in 3 years. It's time. Okay. And she sums up that overall, this case reinforces that the substantial evidence is a relatively low bar. And that was in the case we did most recently, Scarborough. But it is one that we can't overlook. And it's true because make sure that ALJ gave specific reasons why he discredited, in so many words, an allegation based on what other evidence he found in the record. So while he doesn't have to go line by line through the evidence in the 1,000 pages of medical evidence that you submit, the things he does use to make his decision need to be relevant. And if there's relevant ones that and this is me talking, this isn't from the case or the summary, if he leaves out a really significant medical record that is supportive of what, you are asserting, like it would be known to be indicative of pain, say, of the levels you claim. And he doesn't mention it or mentions it, but then doesn't explain why it's not, pivotal or at least effective. That's something you might want to draw out for an appeal, I think. Okie doke, guys. That's it. Toledo versus Commissioner. Good information to keep on top of. I'll talk to you guys later. Bye.